Hi, everyone, and thanks for joining us for today's webinar. We are very, very lucky and honored to have with us Judge Bruce Einhorn. Judge Einhorn served as an immigration judge for over 15 years, earning a reputation as one of the fairest judges on the bench with the highest degree of integrity. You can ask any practitioner that practiced in front of him. He had, contrary to some of the other judges, he's known to be fair and honest and compassionate. Before taking the bench as a judge, Judge Einhorn worked for the U.S. Justice Department's Office of Special Investigations from 1979 to 1990. And as a young lawyer, he worked as a principal draftsperson of the Refugee Relief Act, which was the first time in U.S. history that gave non-citizens the right to apply for asylum in the U.S. He's also served as an adjunct professor of international human rights law and war crime studies at Pepperdine Law School since 1991. Judge Einhorn currently serves as an expert witness and consultant on immigration and nationality matters, in addition to being the executive director and CEO of the Asylum Project. He's also been a professor of law and the director of the Asylum and Refugee Law Clinic at Pepperdine Law School. And finally, as a founding member of both the U.S. Holocaust Memorial Museum in DC and the Museum of Tolerance in Los Angeles, Judge Einhorn has proven his commitment to furthering the principles of justice and tolerance. And here we go.
Well, good afternoon, everyone. I'm very honored to be a part of this meeting. I hope you're able to gather some good from it. I know you'll be able to gather some CLA, but I hope you're able to gather some good from it. I do have a vested, almost parental interest in this subject. As was mentioned, as a young lawyer, I used to tell other now young lawyers, as a young lawyer in the Lincoln administration, I was the principal draftsperson of the modern US law of asylum. We've had a wonderful statue in New York Harbor in my hometown that talks about giving your wretched refuse. You're tired and you're poor. Well, in fact, only in 1980 did we have a modern, generally relevant and general scope statute of asylum. Prior to that, all we had was specific refugee laws designed for specific refugees. For example, those who fled the Holocaust after World War II. And they all concentrated on the review of refugee applications outside of the United States. In fact, asylum refers to people who are already in the United States who, while here, even if here unlawfully, apply for refugee status. And I'll go over with you in general terms now what that statute includes. It was intended, I can tell you, as a fairly broad statute, as a humanitarian remedy. And of course, I've gotten some pushback lately. Former President Trump once referred to me as moronic, and I referred to him in the New York Times saying, quote, "It takes one to know one," unquote. So I've had differences of opinion with a number of leaders, and they're entitled to their view, but I'm going to insist that you understand that when the law was drafted and enacted, it was intended as a humanitarian remedy, not a restrictive remedy. After all, if we had not passed the bill, we would have no asylum. So obviously the statute was meant to expand the possibility that foreign-born people are able to obtain legal status in the United States as refugees. I try not to use the word aliens for foreign-born people because it connotes ideas of human beings or organisms from other countries, other planets rather than other countries. But it does include individuals who have gotten to the United States and apply for asylum here. One thing that the Asylum and Refugee Act does not cover are individuals who want to get out of their country of alleged persecution, but can't. It only applies to individuals who make it across a border, of course, in the US case, to the border of America. And the asylum statute that I helped pass, that I drafted, was in conformity with American obligations under the 1951 United Nations Protocol for the Status and Protection of Refugees, as enacted again under the 1967 amendments thereto. And the Senate passed the amendments and the 1967 protocol. And as you, I'm sure, know, a statute has the authority, a treaty has the authority of a statute. However, in order to enable the provisions of the treaty, Congress in 1980 passed the asylum statute. The asylum statute is meant to protect and grant refugee status to the following individuals who come to this country from abroad. And those are individuals who have suffered or fear a well-founded fear of persecution based on race, religion, which includes ethnicity, nationality, including ethnicity, membership in a particular social group, and, political opinion. So there are 5 grounds for asylum eligibility. Again, they are race, religion, nationality / ethnicity, membership in a particular social group, and political opinion. An individual may establish refugee status by proving a past persecution or a future well-founded fear of persecution. If an individual establishes past persecution, then the burden falls on the government in any proceeding involving asylum to prove by a preponderance of the evidence that the situation in the applicant's home country or the country where the applicant suffered past persecution has changed. So unless the government is able to prove a significant change in the country conditions relevant to an asylum applicant, then the past persecution constitutes a grounds for granting refugee status. With regard to a well-founded fear of future persecution, the applicant for asylum must prove A, a subjective fear of persecution, and B, an objective fear. The subjective fear component means quite clearly, and has been reestablished by courts across the country, as a fear that is credible as to what the applicant actually believes. The objective component is the one with which most people are familiar who practice immigration law, and that is that the applicant for asylum must establish by evidence that he or she has suffered that he or she actually possesses a well-founded fear of persecution for sufficient reasons based on one of the 5 factors, which are, again, race, religion, nationality, membership in a particular social group, or political opinion. Those 5 grounds are independent. That is to say, you don't have to prove all 5 in order to obtain asylum. Although if you want to, you can. You only have to prove 1. Furthermore, there has been a doctrine enacted both in the international theater and under US case law, which holds that even if there is no actuality of such well-founded fear of future persecution, if the applicant is able to establish that the government of his country or those acting with the government have imputed to him one of those grounds for persecution, then the applicant may receive asylum anyway. For example, I had many cases in court involving Central American countries in which the nationals of those countries established a well-founded fear of future persecution because of their political dissident activities against the government. Those individuals sometimes fled ahead of their families. The families then suffered all sorts of physical and/or mental abuse, including incarceration and vigorous interrogation, including torture, in order to punish them for what the family member who fled did, but also to try to obtain from them the whereabouts of the fleeing individual. However, the evidence in those cases was very clear to me on the bench that these individuals who suffered secondary harm were not themselves involved in any political dissident activities. It did not matter. Under US case law, if the government or non-governmental entities imputed to these individuals, or taking another point of view, as the Supreme Court has said, if looking at the incident from the persecutor's point of view, there was a motivation based on one of those 5 factors, regardless of whether the family member was actually involved in any way in the fleeing individual's activities, then that would be enough to establish an asylum applicant's eligibility for asylum relief. And remember that asylum is coterminous with refugee under the statute. If you apply for asylum status and you receive it, then you are declared a refugee. And within a year under US law, you may become a permanent resident of the United States. And then within 5 years, you may apply for and receive United States citizenship via the naturalization process. So to steal Churchill's phrase, the asylum process is not the end, it is the beginning of the end, or if you will, the end of the beginning. In any event, those are the broad contours of the asylum statute. Another additional element that has been added by case law has been the element involving, the element involving government as opposed to non-governmental entities. Traditionally, it was thought that in order to obtain asylum, an applicant for refugee status would have to prove that he or she faced a well-founded fear of persecution based on governmental action. In fact, under US case law, consistent with international treaty law, the individual need only prove that in fact the persecuting agency, if you will, even if a non-governmental agency was one that the government could not or would not suppress. So for example, back in the day, there was in El Salvador a death squad which acted adjacent to the government and whose leaders were in fact the leaders of political parties on the far right, some of whom are actually members of the government. These death squads performed various activities of which the government officially wanted no part. They would hunt down and assassinate the political opponents of the government. And then the government, in a Pontius Pilate sort of way, would wash its hands of the incident and argue that it was not responsible, that it was a non-governmental agent that had performed the injury. In fact, under international and US obligations, the fact that the government was unwilling or unable to stop this adjacent vigilante group was enough to establish the victim's eligibility for asylum, or by imputation, the family's eligibility for asylum, if those relatives were in fact subject to attack. And that leads us to the last of the general categories of asylum eligibility. And it is one that has vexed lawyers for some time, actually since 1980. It is this: the statute and the regulations that have promulgated the details of the statute do not provide a specific burden of proof phrase that applicants for asylum must use in establishing their case. So for example, and by contrast, if an individual in this country is facing criminal prosecution, then the government must prove beyond a reasonable doubt that the elements of the offense have occurred, and then that the facts conform to the relevant law. But in asylum, where the initial burden of proof belongs to the asylum applicant, there is no specific phraseology discussing what that burden of proof is. And so the question arose early, why not? And if you care, why not or don't? What is nevertheless the burden of proof? Now, I will tell you that when we drafted the statute, members of Congress could not agree on an appropriate burden of proof. Most members of Congress felt that the burden of proof should not be all that high because the remedy was a humanitarian one. Some members of Congress felt that in order not to open floodgates, there be a specific burden of proof and that it be mentioned in the statute. In fact, as a compromise, I was told not to include a burden of proof phrasing. And by the way, this compromise is identical to the one formulated in the international treaties that are the basis for our law. Those treaties do not contain a specific burden of proof. In a seminal case in the early 1980s called INS, some of you will remember the old Immigration and Naturalization Service, INS v. Cardoza-Fonseca, the Supreme Court again emphasized that there was no phraseology relevant to a burden of proof, but it also suggested that because asylum was a humanitarian remedy, that even in some cases, not all, but some cases, an adjudicator might grant asylum if there was proven only a 1 in 10 chance that the individual had a well-founded fear of future persecution. Now, some lawyers have misinterpreted this holding to suggest that in every case, an asylum applicant only proved that 10% chance. That is not the situation. It only means via the Supreme Court decision that an adjudicator may consider whether there is even a slim chance of persecution, which is enough. So it gives a broad discretion to the adjudicator, whether an administrative adjudicator or a federal judge. And I'll get to that in a moment. The situation regarding this phraseology has led to the following bifurcation in asylum adjudication. Individuals who come to the United States seeking asylum and who didn't come obviously as refugees must, in the first instance, except for one exception, which I'll get to, must, in the first instance, apply for asylum with what is now the U.S. Citizenship and Immigration Services branch of the Department of Homeland Security. This branch is commonly known as CIS. This is an administrative application process. The individual will advance what is called an affirmative application, and the administrative officer, known as the asylum officer, will review that application after having interviewed the applicant and obtaining from the applicant any relevant evidence the applicant feels he possesses. And obviously the credibility of the applicant's testimony and the credibility of the documents he offers are always subject to consideration. The asylum officer may also, on his own initiative, obtain information relevant to the asylum claim. So, for example, it is common, if not required, and I would tell you that within CIS it is required as a practical matter, that asylum officers look at the annual country condition reports of human rights practices in the country from which the asylum applicant is seeking refugee relief, either the country of his last departure or the habitual residence, or in most cases, the country of his nationality and birth. So if an individual applies for asylum from, for example, Ukraine, then the asylum officer will look at the State Department report, the most recent report, on country conditions and human rights practices regarding the Ukraine. Now, the State Department every year publishes a compendium of human rights practices for every nation in the world, except, of course, for ours. And that document includes chapters for each country. It is the chapter relevant to the asylum applicant to which the asylum officer will refer, and that also applies in any subsequent proceedings before a federal immigration court, and we'll get to that. So as I say, the asylum applicant will generally apply for an affirmative grant of asylum with CIS. If CIS grants asylum, then the matter is closed and the applicant will receive asylum/refugee status. If the CIS officer, the asylum officer, decides to deny asylum, or if the CIS officer makes a pass, called a referral, and does not choose to come down on the issue, something a judge may never do, then under both situations, the asylum applicant's case will be referred to the Federal Immigration Court as part of an overall prosecution for removal and deportation at the hands of the U.S. Immigrations and Customs Enforcement Agency, known commonly as ICE, an agency that is also part of the Department of Homeland Security. ICE is the prosecuting agency in removal and deportation proceedings. So essentially, CIS will refer a no grant case to ICE, and ICE then has the right, within its discretion, to file a removal case with the immigration court. If it does so file such a case, then the asylum application will be made part of the record, and in defense of any allegations or charges that may be proven regarding the removability of asylum for other reasons, the asylum applicant, now known as the respondent, may raise again as a defensive application the asylum materials. So court proceedings may involve defensive applications for asylum. Now, why do I say that non-grant cases from asylum officers are usually referred to ICE officials for a prosecution for removal or deportation? It is because 99% of all those who apply for asylum with CIS and have their materials reviewed by an asylum officer are here unlawfully. Many of them come here on visitors' visas or other non-immigrant visas, which have a time period of legality. Some of them come here on work-related non-immigrant visas and do something that puts them outside the terms of their visa. And in either situation, the individual no longer has lawful status when he or she applies for asylum with CIS, and therefore continues to have no status when ICE refers them to court for a removal or deportation case. Thus, the asylum application in court is a defense to any removal or deportation of an individual who is otherwise here unlawfully. And in most asylum cases before judges, it is the case that asylum applicants will concede their removability, their unlawful status, subject only to a request for asylum relief. By the way, an application for asylum is automatically considered an application for withholding of removal and relief under the Convention Against Torture, to which the US is a signatory. The withholding of removal provision is part of US law, and the Convention Against Torture provision is incorporated into US law under federal regulation. And just briefly, to establish withholding of removal, a non-US citizen must prove by a clear probability, which has been construed as a preponderance of the evidence, that the applicant will suffer or has suffered persecution on account of the same 5 grounds that exist in the asylum law. The withholding of removal status was passed in a statute in 1952, before a general grant of asylum was permissible. Why? Because there is a principle in international law followed by the US, or I should say, which the US is obliged to follow, called non-refoulement, which in English means non-return. And it states that an individual who has established a well-founded fear of future persecution may not be returned to the country where persecution is feared. That is a cardinal principle of law. And in 1952, Congress passed the Withholding of Removal statute. Now, again, it was not a broad grant of asylum. What's the difference? If you obtain a withholding of removal, you may not necessarily be on the track for permanent residency. If you obtain asylum, then you are on that track, and you may not be removed in the future unless you commit some grievous offense. If you receive only a withholding of removal, then the government may seek to remove you to a third country, not ours, not the country where you have established that you will be persecuted, but a third country. And this is connected to the proceedings in court, because when a judge asks an asylum applicant to what nation he wishes to be removed if he loses his case, the asylum applicant, if smart or represented by counsel, will decline to designate a country. The government will then ask the court to designate a country, and the court will designate the country where respondent is afraid to return, but also the government may request the designation of another country. And it is the other country where the respondent, even if granted withholding, may be sent. Does that happen a lot? No, but it does happen. And that makes the withholding remedy less important and powerful to the respondent, to the asylum seeker, than asylum itself. As to the Convention Against Torture, it is available to those foreign-born individuals who argue in court that they have suffered or will in the future suffer torture if returned to their country. Torture is generally defined as a severe physical or emotional abuse, and it is not required that that abuse, cruel and unusual treatment or torture itself, be based on any of the 5 factors relevant to asylum. but the burden of proof is higher insofar as the level of abuse must be proved to be extreme. The problem with receiving relief under the Torture Convention is that an individual may receive relief, but also in some circumstances, and as related to withholding of removal, be sent to a third country. Does that happen a lot? No, but it can happen. And that is why asylum is the preferred remedy of relief. And that is why we will be speaking about asylum for the remainder of our time together. Now, obviously, I can't cover all modern and major developments in the law and policy regarding asylum, but I'm going to try to give you the highlights and some details of the most important issues. During the Trump administration, the president and his Secretary of Homeland Security, together with the Attorney General, faced the issue of asylum requests coming from individuals who were attempting to enter the United States from Mexico. In fact, who more often than not had already entered the United States from Mexico and applied for asylum with CIS. The Trump administration promulgated what are known as the Migrant Protection Protocols, or the MPPs. The MPP is essentially the reverse of how it is described. There is nothing in it that protects migrants or asylum seekers. It holds that individuals seeking asylum who have come across the border from Mexico to the United States, whether Mexicans or not, be returned to Mexico until and unless they receive a hearing from an asylum officer and/or a federal immigration judge. So the individuals must make our borders, and then they will be returned to Mexico pending a hearing. There are a lot of problems with that. At least some people believe, and I believe there are a lot of problems with that. First of all, I would argue, and many have argued, that the MPPs are inconsistent with the principle of non-refoulement or non-return. That is to say, while an individual is returned to Mexico, the individual is in a much more vulnerable position in Mexico from being returned to his or her country of nationality, even before asylum proceedings in the US get started. Another problem with the MPPs is that individuals in Mexico are at the mercy of the Mexican government. Now, Mexico is not exactly a dictatorship by any means. However, the Mexicans also have immigration challenges, and they may or may not seek to remove these individuals, usually who are living in migrant camps by the border, and seek to remove them to their own countries. At which point, these individuals who have already crossed our border, applied for asylum, and only then returned to Mexico, will lose their opportunity for a hearing before an asylum officer and/or a federal immigration judge. And that, to me, smacks of a denial of non-refoulement, and some have argued a denial of due process of law in the United States under the Fifth Amendment of our Constitution that applies to federal government action. Also, it strikes me that as a practical matter, the individuals who are subject to the MPPs are less likely to receive relief in court. I am supported in my view by statistical surveys which have indicated that as to those individuals subject to MPPs who ultimately obtain hearings before immigration judges, the granting of relief has gone from an average of 20% to an average of 1%. The overwhelmingly significant trend downward strikes me as a practical matter, as an advancement of a political agenda by the executive branch, and therefore as an interference in due process. The Biden administration has indicated that it wishes to revise the MPPs. However, in a recent Supreme Court decision, the High Court stated that the Biden administration must comply with rulings to remain in Mexico policy with regard to asylum seekers who apply for asylum here are then sent back to Mexico. Again, the Supreme Court has stated that the Biden administration, regardless of its tendency to change policy, must comply with the ruling to restart the Remain in Mexico program known as the MPPs. Now, whether this will change or not may depend on Congress. If Congress were to enact a statute overruling the MPP policy that was advanced in the Trump administration, then I'm sure the Supreme Court would defer to the executive branch, to the administration's ability to end the MPP policy. However, there appears to be virtually no chance in Congress, and there appears to be no chance in Congress after the elections are held in November, that the MPP policy will be overruled by a statutory amendment. Therefore, the Biden administration is left fighting this issue and trying to decide whether a regulatory change might survive a Supreme Court attack. I am pessimistic because the Supreme Court has indicated very strongly that the Remain in Mexico program must be given preference. However, I would argue, and many have argued, that the MPP program was enacted by executive decision and not by congressional statute, and therefore a regulatory change might be the way to go. And that is being worked on. And I have occasionally consulted with the Biden administration, and I believe, and I have told them, I believe, that we ought to try a regulatory change to see what happens, because the statutory change just isn't forthcoming. If you agree on the MPP program, then it is still the status quo. Now, those are depressing ideas and policies that have come out. But there is also another Supreme Court, another federal court decision that has limited the Biden administration's discretion in changing the immigration policies of the Trump administration. And thus, depending on whether you agree with these policies, which I'll explain, you may be pleased or not so pleased by this federal court decision. The administration, through the Department of Homeland Security, has enacted prosecutorial discretion provisions that indicate that there will be a hierarchy of prosecution and removal proceedings for individuals coming to the United States and more often than not coming across the border. In other words, criminal issues involving a non-citizen will make it much more likely under this new policy that the said individual will be subject to removal proceedings. Non-serious offenses or asylum-related applications will not be given priority except and unless the asylum seeker wants his case to be given priority. Well, in light of these changes, which were promulgated by the Secretary of Homeland Security, Ale Mayorkas, who happens to be a friend of mine, and to which the Border Patrol, ICE, and CIS were made subject, were denounced in a lawsuit filed by the states of Texas and Louisiana before a federal judge in Texas. And the federal judge, a Trump appointee, in a decision of which, frankly, I disapprove, blocked the implementation of the DHS policy of discretion, of limiting immigration enforcement, depending on the hierarchy of conduct of the non-citizen. The judge argued that this policy by the Department of Homeland Security was inconsistent with the congressional statute regarding the ordering of removal proceedings for any individual not lawfully present in the United States. Now, the government has argued, and I share this view, that it is not inconsistent with this prosecutorial statute for the prosecutorial agency, Homeland Security, to engage in prosecutorial discretion. After all, district attorneys in this country and US attorneys in this country typically on a daily basis engage in prosecutorial discretion. Otherwise, there would be no plea bargaining. Otherwise, there would be no decision not to prosecute some individuals in return for immunity, just to name a few examples. Also, it is widely believed that if there were no discretionary authority in state and federal prosecutors in criminal cases, the justice decision would collapse of its own weight because of the number of cases that would be forced on the courts. Well, the same is true in the immigration law. The number of cases that would be foisted on immigration courts where there are now 2 and 3 year waits on hearings would be unbearable. The immigration court and the courts around the country involving immigration judges would collapse of their own weight. I also question whether states have the right to challenge a federal policy on immigration, because immigration has been held over and over again to be a federal policy. States cannot enact immigration laws. On the other hand, this judge, a Trump appointee, took the view otherwise, and the government has indicated that will appeal, but in the meantime, the judge has issued a nationwide ban on this prosecutorial discretion policy. So there have been a series of setbacks to any rules that might limit the ability of the government to hear asylum cases of those who come here without sending them back, and to also create a hierarchy in which criminal cases or those involving asylum seekers who want their cases heard will be adjudicated first and the others adjudicated later. The Biden administration has tried something else. It has promulgated new rules that aim to decide US asylum cases more quickly. Those rules are dependent in part with adding more asylum officers and immigration judges. Whether the rules in their final form maintain the policy of the administration to liberalize the situation, and whether funding exists for the adding of more adjudicative officials, administrative and judicial, are to this point somewhat problematic. My fellow immigration judges have told me that the weight and pressure of caseloads continues to be very, very heavy. The situation, therefore, in immigration law is a very problematic one. Under the Trump administration, the availability of asylum, because of certain policies involving the handling of asylum applications, was narrowed. After all, laws can be narrowed not just by subsequent legislation, but also by executive, fiat, and federal regulations that create an enforcement decision that fundamentally changes the humanitarian impact of the asylum, regardless of what congressional intent was in 1980. A lot of courts now don't seem to care much about that intent, which reminds me of the old saying of a parent that you raise your children, they grow up and they do what they want. Well, I drafted the asylum statute, but given the way in which it's handled by administrations and courts, that statute appears to be doing what it wants. So there is a very significant conflict between what administrations have done and what the statute says, at least in my opinion, and what the current administration is trying to do, and what certain federal judges are allowing it to do pursuant to state lawsuits, which in my judgment may not even be based on proper standings. One final thing to end my discussion on a positive note, at least for me a positive. Under the Trump administration, there was enacted a decision of the Attorney General. Now, just to familiarize you with the crazy quilt of asylum adjudications and immigration case adjudications, any decision by a US federal immigration judge is first reviewed upon appeal by the United States Board or Court of Immigration Appeals. That decision may then be appealed to the relevant Federal Circuit Court of Appeals, from which the non-citizen first requested asylum, or where ICE first began the immigration proceedings. So if a person in Texas applied for asylum and lost, applied to the Board of Immigration Appeals and lost, then he may apply to the Fifth Circuit for relief. Now, the problem is that once you get to the Federal Court of Appeals, the avenues of review are substantially narrow based on subsequent amendments to the 1980 statute. However, although the Attorney General may not review, revise, or reverse the decision of a US immigration judge, he or she may review, revise, and reverse a decision of the Board of Immigration Appeals. Under the Trump administration, Attorney General Jeff Sessions issued a decision in matter of AB, which stated as a general rule that immigration adjudication should not be permitted to grant asylum to immigrants or non-immigrants seeking asylum who are advancing the argument that they are members of a particular social group because they were subject to domestic abuse in cases in which the government or a non-governmental entity was indifferent, or where the government or non-governmental entity entered into an acquiescence of the matter. Attorney General Sessions stated that these issues were largely criminal issues and did not relate to any interpretation of the particular social group category. Now, I disagree because prior to my asylum, I had granted and was upheld in granting asylum requests based on domestic abuse for the very reasons that Mr. Sessions disagreed. Well, Judge Garland, whom I also know, our Attorney General now, has rescinded matter of AB, has reversed the decision of the Attorney General, and until there are subsequent regulations, has basically returned us to the status quo ante, which means that immigration judges may consider whether domestic abuse constitutes persecution based on membership in a particular social group. And we'll see how that goes. So I hope I haven't overly confused you with a very, very complicated issue. I appreciate in advance your attention, and I would be happy to receive questions. And I don't think I can hear you.
Oh, sorry.
Now
Um,
I can hear you.
So far, there's Joyce says hi, Judge Einhorn.
Hello, Joyce. Good to hear from you, or see you, or not constructively see you.
She's in the ether. I had a question. If President Trump was able to, do the stay in Mexico by executive order, why? I mean, what I didn't really understand that decision about why, pretty much any other executive order can always be rescinded by executive
Well,
order.
that was the Biden administration's position, that if the Biden administration wants to undo executive action that was undertaken by the Trump administration, then it should be able to do so. But the Supreme Court stated that for the moment, the return to Mexico policy be permitted. The reason I'm shuffling papers, I want to make sure I understand the reasoning, which I know. The majority stated that the administration, that is the present administration, had not done enough to say why it was changing the policy.
Mhm.
Now, I have to tell you, it seems to me rather plain, without further explication, why the Biden administration attempted to change the policy. Because the statute suggests that asylum seekers are considered for asylum after they come to the United States, at an airport, at a border, etc. I don't understand why the Biden administration has to write 20 pages as a predicate to engaging in its action. But by a 6-3 majority, the Supreme Court has stated otherwise. It has stated we will review this issue, but we want more of an explication by President Biden as to why he's changing the policy. I think this is a result of who sits on the Supreme Court. I hate to be so blunt. I've always said to people that judicial issues should be among the most important when people vote, because elected officials change things for a few years, judges change things for generations. And I think the majority of the Supreme Court has now made it more and more difficult for the asylum statute to be interpreted as a humanitarian one for whatever reason. And I think it just tends to defer to the previous actions of the administration that frankly appointed so many of those judges. Others may disagree, but I think that sometimes when it walks like a duck and talks like a duck, it's a duck.
Also, when you were saying that, okay, for cases that USCIS denies, when they deny the asylum application and then it gets referred to ICE, if the person
referred to ICE for a prosecution and immigration.
Right, but if the person isn't out of status when
and that doesn't happen.
So
that doesn't happen. But of course, what happens when the person does come out of status? So you apply for asylum when your tourist visa is still in effect.
Right.
You're denied asylum. Well, when your tourist visa goes out of effect, you become unlawfully here. Now, the government may or may not attempt to find you, but you then live in the twilight between legal action and no legal action. You technically can't work. We can't find you for income tax purposes. And you are always worried that even if you're pulled over for speeding, that the local police in certain jurisdictions, not necessarily LA, but certain jurisdictions, will look in its data bank, find that you're not lawfully here after having asked you whether you are, and therefore arrest you for speeding, but then immediately transfer you to ICE detention. And I should point out that when you're a migrant seeking asylum, either in detention here or when you return to Mexico pending further action, the likelihood that you're going to obtain legal counsel becomes more remote than ever.
Right.
Because lawyers may not be able to find you and help you either in Mexico or in detention centers where people are transferred all over the country. And I submit they're transferred all over the country to make it difficult for defense organizations to track them. Whether or not that's true, they are transferred a lot. And individuals don't want to be in detention forever. So as a practical matter, many of them just give up, even if their claims are strong. By the way, there is no statutory or regulatory right to counsel in these cases. That probably should change. That would involve federal funding for public defense lawyers. And we're all going to have to say good luck to that for the foreseeable future. While the economy is bad, I can guarantee you non-immigrants seeking asylum will not be the priority of either voters or politicians.
I was going to ask you about your thoughts on because there has been a movement, I feel like recently, I forget which group, but there was some group recently that was trying to get a lot of people on social media to get people interested in that topic of requiring court appointed, like in criminal court, and they're treated as criminals in asylum.
As a practical matter, they are. I can tell you that observing them in court, if I did see them in custody, or if they were subject to economically degrading positions here because they're at the mercy of employers who can at any time have turned them in and then do, these people feel like prisoners. Now, I'm not suggesting they're all saints, but most of them are not devils. Right. They're human beings. And look, if we believe we are a nation of laws and a nation of humanitarian relief measures, then we have to act that way. We have the largest number of asylum seekers in the world. And it's not just because we had a liberal policy. It's because of our values. Our nation is defined by its values, not by our land, not by however beautiful it is, but by our values.
Right. Okay, we have a question in the Q&A.
Okay.
Joan, how are they working the cases that need appeal to the BIA but were sent back to Mexico and forced to leave to other countries? Are they out of luck on appeal?
Well, no. I mean, if remember that when the individual has a court hearing before a federal judge, he or she will be allowed to come back if we can find the person. Otherwise, if that person cannot be found because he has been raped or because she has been abused, that person will be subject to an in absentia order of removal and a denial of asylum forever. But let's suppose we have a situation that is a little less onerous. The individual is returned to Mexico, comes to the asylum hearing, is denied asylum by an immigration judge other than me, and then appeals. While that appeal is pending, the MPP seem to indicate that the individual should be allowed to remain in the United States. As a practical matter, I'm not sure what's happening, but the MPPs do not require that the individual go back again to Mexico or to the country of original residence. Does the BIA quickly handle these appeals? Their backlog is also terrible. That is to say, the BIA judges' backlog are terrible. They're not indecent people, but they're under a terrible pressure. And you know, political pressure under the Trump administration has scarred a lot of people. I remember under the George W. Bush administration having differences with the Bush administration, and the Bush administration often appealed my decisions. People said to me, "You're going to upset the administration." And my job is, and I said, my job is to comfort the afflicted and afflict the comfortable. My job is to create a balance. I'm a judge. I'm going to be here for life if I want to be. Of what am I afraid? And there are a lot of immigration judges, both conservatives and liberals, and by the way, those in between, who feel that way. But a lot of judges have been looking over their shoulders. And I don't think a year and a half of the Biden administration has necessarily acted as a balm to those wounds and scars.
Oh, Joan is saying, but that is not happening. They're actually sending people back with removal, or based on her last question, with fake next hearings, so Mexico will accept them back.
Well, if that's happened, then these people may, to use a legal term, they may be screwed. because while technically they are allowed to come to their administrative hearings before the Board of Immigration Appeals, if they come back to Mexico and all of the board hearings are held in the DC area, which they are,
Right.
they're just, unless they're very wealthy, and most asylum applicants are not very wealthy, they're not going to be able to make it to the hearing. So once they go to Mexico, they may not come back unless the Jones of the world are able to fund them. And also, let's be realistic. When a person is in Mexico already, a lot of adjudicators are not going to make granting them asylum a priority. After all, they're not here. They might still be alive. So what's the big deal? Well, alive and living are two different things.
Right.
So Joan, I'm sorry. I guess things have gotten even worse than I thought they were, which doesn't surprise me. It just upsets me.
Oh, wow.
Yeah, this is an oh wow policy. And by the way, I have conservative friends who don't like the situation either because it's taken discretion away from judges.
Mm-hmm.
I mean, judges are intelligent. They're supposed to be intelligent enough to look at these facts and apply the law. And a lot of conservative judges say, you know, I can handle this. I can do this. I'm not a Bolshevik. I'll handle it.
Bolshevik.
So give me a chance to do this and stop messing with the process. I mean, judges are supposed to be judges, not ministerial officials who stamp things. And I know many conservative judges who are as upset as I. And I feel badly for them too.
What are your thoughts on, because immigration judges aren't really, they're not Article 3 judges and they're not Article 1 judges. And I remember I feel like in the 80s, 90s, there was a movement to try and get them under Article 1 as administrative law judges, but then I forget which,
well,
it was too much work.
I can give you a very quick history of what happened. Many years ago, probably before either you were a gleam in your parents' eyes or before you were a college student, certainly, Republicans, including a friend of mine, Bill McCullum from Florida, who is retired, and Democrats proposed that we be converted to Article 1 status, which would make us similar to the tax court. Mm-hmm. It would have sent us out from under the executive branch. Now, legally, we are independent now, but it would have provided an institutional framework. Mm-hmm. We're not going to become Article 3 judges, right, because only district court judges and those who review their decision are Article 3 judges. But there was a push that almost achieved success to make us Article 1 judges. There is now a push again, but I think that it isn't a priority. I think if you ask the Biden administration and every Democrat in Congress and a few Republicans whether this is a good idea, they would say yes. I mean, put them in Article 1, it's fine with us. I mean, they still are going to have their responsibilities. And if they want to be more independent institutionally, God love them, it will be their fault if they screw that up, not ours. But it's not a priority, and it may be seen by some in Congress as an attempt to create appointments that are more liberal. I don't think the presidents will necessarily appoint wildly liberal people, either under President Biden or his successors. I just don't see that happening. I think it's a good idea because I think it would enhance the status of the judges. I was treated with great status, but some judges liked to hide behind the fact that they were part of an institution that, regardless of their independence, was not independent itself, right, independent themselves. I felt I was responsible not only for myself, but my court. I was an officer of my court, or as John Roberts told me once, my job is also to protect the integrity and independence of the entire judiciary. Well, I was a presiding judge for a very short amount of time, and that was my job too. It would have been a lot easier if we had been an Article 1 court. Will it happen? Yes. Will I be alive for it? Ask my doctors.
Well, it's you know, the one court that seems wildly inconsistent in terms of judges, in terms of it's
I agree. By the way,
there's very little accountability if you have a judge that's abusive, because I've seen a very verbally abusive
and I beat up those judges in the lunchroom, so I know.
Right. And so you would never see an article, a tax judge or district court judge ever have sort of the balls, I guess, to act like that.
No, whether it's better to have a somewhat arrogant judge who is fair and independent in the extreme with regard to appointments of his staff, budget, and decisions than a meek judge who is always looking over his shoulder, trying to decide cases and worried about being reversed. I wasn't worried. And you know what? The more fair and less worried you are, the more you're affirmed.
Right.
And I had federal circuit judges like the late Harry Ferguson, the late Steve Reinhardt, and even my friend Alex Kaczynski, who said to me, yeah, judges should be stand-up people. I agree. I think it's very unfair. By the way, the Administrative Procedure Act covers administrative law judges like Social Security judges, judges in the Labor Department, but their decisions are recommendations. Right. Our decisions were final, subject to appeal. So making us Article 1 judges makes sense. It holds us as judges accountable for what we do. And that's what judges should be, accountable. If you invest a judge with the status of authority that he or she deserves, I believe judges will live up to the expectations of that authority. People are capable of growth, and a lot of judges who are already good will become great. Right. And I know that, having served with some truly superb judges on the left and the right who very much wanted Article 1 status.
Great. I hope that happens.
So do I. So all of you, lobby. Not that our senators and Congress people need to lobby, but lobby. Make it a priority issue.
Yes. Okay, and I think we're out of time, and I think we're out of questions. Oh, Joan says, thanks a lot.
Joan, thank you.
Okay. And if there's no other questions, I think we are out of time.
Well, I thank you all. I thank you especially. This has been a rare treat. I write a lot of scholarly text. I've co-authored books that I can't even afford to buy on asylum adjudication and trauma and human rights applicants. But this is a chance to speak to intelligent people, busy people, who don't have time to read my 14 law review articles and my 5 books, but want to exchange with me their understandings and perceptions. So now people will go to their offices or go home, intelligent people of all views, and think about these matters that will have an impact on who lives here and also who may be governor of this state in 20 years.
Okay, so thank you everyone for coming. There's Larry says good presentation. Lori says that was excellent. Thank you.
Thank you, guys.
Lawyer, it was great. So
okay, God bless and have a great weekend.
Great, thank you everyone, and you will be getting your certificates mailed in the email.
And you may send my Nobel Prize to me.
Yes, I will.
Take care, everyone. Bye.
Right, thank you. Bye.